5 seconds to go. Start. In this regard, Popular Estates had examined PW5 and relied on a few documents to establish that the properties were cultivated with rubber, coffee and cardamom. PW5 was the manager of the plantation. His services began in 1969 as office assistant. He stated in his evidence that at that stage in 1969 1130 acres of the estate was plantation and that 160 acres were also planted before commencement of the act. The tribunal brushed aside this evidence, concluding that nothing tangible emerged from it and that Popular Estates necessarily had to prove that the disputed properties were principally cultivated with rubber, coffee or cardamom. The tribunal faulted PW5's evidence as not being precise with respect to the extent of properties which had been planted with the different crops. It also faulted his evidence on the ground that he had limited knowledge since he had to deal only with the estate when he became an estate supervisor in 1974-75. It was concluded that he did not have any direct knowledge with respect to the nature or extent of cultivation. The tribunal considered Exhibit A37 to A41 holding that they were title deeds. It was noted that Exhibit A41 was executed in 1972, that is, after the appointment date, and being a photocopy was in any case inadmissible. The other documents had come into existence before the appointed day. However, their recitals did not disclose expressly that before the appointed date the properties were cultivated with rubber, coffee and cardamom. The tribunal noted that the schedules in two of the documents, Exhibit A37 and 38, showed that the properties were cultivated with cardamom. These were to the extent of 72.762 hectares and 89.92 acres, but were not proved to be land within the disputed properties. The tribunal noted that this court's holding was that the board's orders were not binding on the authorities under the Vesting Act. It proceeded to analyze Exhibit A50 and 51, which was the draft statement of lands surrendered to the government under the KLR Act and the certified copy of the order of the Taluk Land Board respectively. In this context, the tribunal considered objection number 7 that Popular Automobiles owned 1530.4 acres in Maloth village and that out of this the private forest coming within the purview of the Madras Act an extent of 1127.50 acres had been converted into plantation. The tribunal discarded the board's findings as inconclusive. The tribunal further rejected the evidence of PW1 the range forest officer who had deposed before the earlier tribunal proceedings in OA 242 and 243 of 1974 to say that the dispute was confined to 100 hectares. Stop.